I want to thank, of course, the organizers, the Professor Sasperti, Dr. Bizzarri, for involving me. It's a great pleasure. I have enjoyed the presentation this morning. I learned a great deal of things, so I'm sure that I'm gonna learn a lot from these presentations as well. But having said that, I'm gonna serve as the bad cop inevitably to, try to give you the possibility of enriching the discussion and giving everybody the possibility of presenting their research. So I will start and I'm going to follow the alphabetical order. So the first the presenter is going to be Giulia Battaglia. Giulia Battaglia is a research fellow in constitutional law at the University of Pisa, and she's going to present the paper entitled Disinformation and Electoral Integrity and the Role of Courts, Insights from the Venice Commission's Soft Law. Giulia, thanks indeed for being with us. You have 12 minutes, ready where you are.
Thank you, Professor Martinico. First of all, I would like to thank the workshop scientific organizer, Professor Sperti and Dr. Bizzarri. And I would also like to thank the speaker who preceded us for their valuable insights. Well, among the arguments presented by the Romanian Constitutional Court in the decision of last December, some international and supranational references stand out, which, as authoritative scholars have noted, appear particularly significant in the economy of the court's reasoning. In addition to the regulation number 900 and 2024 on transparency and targeting of political advertising, which will apply from October the 10th, I refer above all to the interpretative declaration of the Code of Good Practice in Electoral Matters concerning digital technologies and artificial intelligence, adopted by the Venice Commission on December 6, almost simultaneously with the ruling. The judge of Bucharest recalled the aforementioned document in several points and seems to rely on it to support and justify the broad interpretation of its duty to ensure compliance with the procedure for presidential election in order to compensate for the inaction of other state actors. In particular, the court expressly refers to the point where the declaration affirms the state positive obligation and responsibility to address the challenges posed by organized information disorder campaigns and prevent undue interference with the principle of the European electoral heritage, as well as the obligation to build resilience among voters and to raise public awareness about the use of digital technologies in election. Against this background, the court's reliance on this soft law instrument is far from marginal. Rather, it paves the way for some broader reflections on in particular, the contribution of such instrument in supporting institutional actors, including the judiciary, in addressing new threats to the integrity of democratic processes, and the role of the Venice Commission in consolidating Europe's constitutional heritage in electoral matters, particularly in the face of emerging risks that threaten the regularity and transparency of election. The aforementioned declaration is, in fact, presented as an update to the better-known Code of the Practice in Electoral Matters, which forms the cornerstone of all the Venice Commission's constitutional assistance activity in the electoral field. This document has been mentioned already this morning, but allow me to provide some important callbacks. The code was drafted by the Commission in 2002 on behalf of the Parliamentary Assembly, which subsequently approved the final text, with the task of identifying and consolidating in a single document the principle enshrined in international treaties and reflected in the electoral system of most of Council of Europe member states, as well as with the aim of providing guidelines for the conduct of democratic elections. The document consists of 2 parts and is accompanied by an explanatory report. The first part sets out the 5 principles that constitute the hard core of the European electoral heritage, namely universal, equal, free, secret, and direct suffrage, and the regularity of elections. The second part sets out the conditions necessary for implementing this principle. The reference is first and foremost to respect for fundamental rights, starting with those most closely related to the principle of democracy, such as freedom of expressions, assembly, and association. Secondly, the code establishes the optimal level of sources governing the electoral system and then focuses on the importance of its stability. Finally, the code highlights the centrality of procedural guarantees. Among these, as Professor Sperti has pointed out this morning, the Commission places particular emphasis on the implementation of an effective appeals system. In this regard, the Code specifies on the one hand that if the electoral law provisions are to be more than just words on a page, failure to comply with electoral law must be open to a challenge before an appeal body, and that in any case, a final appeal before a court must be possible. On the other hand, it specifies that the authority to annul the election may be exercised if the irregularities could have influenced the result. In this respect, it is worth mentioning the urgent report published in January, widely illustrated this morning by Professor Monti, in which the Commission addresses from a more general point of view the very issue raised in the Romanian case and what it is at stake in this seminar. Under what condition and on the basis of what legal rules can a constitutional court annul the result of election? Based on the conventional case law, starting from Rees and others versus Bulgaria, the report clarifies that the annulment of part of or all the elections can only be allowed in extremely exceptional circumstances, as a measure of last resort and only on condition that the irregularities in the electoral processes could have influenced the outcome of the vote. Although not legally binding, the code is far from being negligible. Drafted by a technical body, but on behalf of the Parliamentary Assembly, which approved the final version in 2003, the document has indeed a recognitive character. It collects principles already present in international treaties and in the European case law as well. It is precisely this nature, according to some scholars, that constitutes its strength. It does not innovate, but clarifies and summarizes shared rules and practices whose legal effectiveness depend on the acts and sources to which it refers. However, to fully grasp the significance of the code, as well as its additions and applications, such as the interpretative declaration, it is necessary to situate it within the broader evolution of the Venice Commission. Established in the 1990s, the Commission has played a decisive role in first in the democratic transition in Eastern Europe, and then in monitoring compliance with democratic standards and the rule of law, and more recently in countering democratic backsliding. With the authority it has gained in this field, the Commission's function now extend far beyond the borders of the former Warsaw Pact countries and the Council of Europe itself. Consider, for example, the recent opinion given to the Inter-American Court of Human Rights on the value of democracy. Its function takes the form of a wide range of constitutional assistance activities whose common thread is the reference to the European constitutional heritage as an assessment parameter. To this regard, it is worth noting that the identification of this parameter requires the Commission to carry out a significant interpretative work. It is necessary to identify European constitutional tradition in relation to specific problems or issues, which is by no means effortless, as Professor Sperti pointed out, due to the heterogeneity of the solution offered by electoral laws, and to update existing principles to new challenges and threats. What is particularly important, though, is that the Commission's positions do not remain at a cultural level. In fact, they are often taken up and consolidated in case law, especially of supranational courts, to point of becoming genuine points of reference for their argumentation. This gives this instrument an effectiveness that goes beyond soft law, placing the Commission, as it has been said, as a player in a third level of integration alongside political and judicial institutions in the areas of democracy, fundamental rights, and the rule of law. From this latter point of view, the relationship between the Venice Commission and the Strasbourg Court, which is structured on three main levels, deserves attention. Firstly, the Commission draws on the Court's case law in its work. A recent example is the aforementioned urgent report published in January, where the Commission reconstructed the European Court's law on the annulment of election results. Secondly, it participated in proceedings pending before the court as amicus curiae, and finally, even in the absence of a formal opinion, the court itself frequently refers to the Commission opinions, recognizing their argumentation and systematic value. Precisely from this angle, I cannot avoid referring to the ruling of the Strasbourg Court, Bradshaw's and others versus United Kingdom of July 2025. In that case, a group of parliamentarians complained under Article 3 of Protocol Number 1 that the United Kingdom had failed to investigate foreign interference, in particular by Russia, in democratic election, and had not put in place an effective legal framework to comply with its obligation. As expressly stated by the court, for the first time, the Strasbourg judge examined a situation where the conditions threatening free election were created by external state and non-state actors using this information as a tool to manipulate the process. The court concludes with the rejection of the appeal and the recognition of a wide margin of appreciation. It also remarked the difficulty to assess precisely the impact that the dissemination of disinformation and the conduct of the influence campaign may have on individual voters and by extension on the outcome of a given election. Nevertheless, in keeping in line with the Venice Commission interpretative declaration repeatedly recalled in the judgment, the court established that where there is a real risk that as a result of interference by a hostile state, the rights of voters within a member state may be restricted to such an extent as to undermine their very essence and to deprive them of their effectiveness, Article 3 may require that states to take positive measures to protect the integrity of its electoral processes and to review those measures periodically. The decision states also that states are not required to wait before intervening until a threat to democracy is sufficiently established and imminent. The ruling does not directly address the role of court, but it allows me to bring my cursory reflection to some conclusions. The scale of electoral interference and the speed of this information campaign make it necessary to update existing rules and principles in a timely manner. This is clearly illustrated by the rapid succession of the mentioned statement, with the Bradshaw ruling arriving just a few months after the decision of the Romanian Constitutional Court and the publication of the Venice Commission interpretative declaration, although it refers to an event dating back to 2019. The succession is undoubtedly significant. At the same time, the ruling of the Strasbourg Court seems to be part of a process of progressive specification, I conclude, of European electoral heritage in the face of new challenges posed by the digital sphere. In this process, soft law instruments such as the Venice Commission Interpretative Declaration can play a significant role in the orienting the interpretation of electoral issues by the court in the digital age, as well as the delimitation of their interpretation, thanks also to the specific monitoring and follow-up functions and of the electoral processes and to their more flexible approach. Obviously, as stated by the previous speaker, this synergy cannot replace the role of the legislator, but it can contribute to the clarification, to the concrete clarification of states' positive obligation to protect electoral processes and safeguard democracy and implementation of European legislation, as well as the interplay between Article 10, freedom of expression, and Article 3, free election, in the context of election interference through digital disinformation. Thank you.
Thank you very much, Julia. Thanks indeed. I guess we'll have time to discuss whether soft law is really soft in this ambit, because I think it's very relevant. Actually, it seems it binds a lot. Actually, okay. So thanks so much. And now I pass the ball to Rachele Bizzarri. Everybody knows Rachele, who is the postdoctoral research fellow in comparative public law here at the University of Pisa. She's going to talk about addressing electoral disinformation, the interplay of courts and knowledge institutions. Where you are, thank you.
Thank you, Giuseppe. I think I'll go straight to the point. This morning discussion highlighted that disinformation and misinformation have become a serious and growing threat to democracies worldwide. In 2024 alone, the Global Election Monitor recorded disinformation narratives in 43 of 54 national elections observed, which is about 80% of all cases. And from a constitutional perspective, these dynamics raise at least three challenges. First, disinformation can undermine the very functioning of electoral procedures by casting doubt on voting mechanism and technology, ballot counting, and the integrity of electoral authorities. Second, it affects citizens' ability to make free and informed decisions. And third, false information may reach the judiciary through spurious lawsuits meant to spread suspicion or intimidate election officials, or when courts themselves become the target of disinformation campaign. So we know that judges are often called upon to respond to these challenges and are becoming key actors in navigating the informational dimension of democracy. Yet, judicial decisions are often reactive, fragmented, handled on a case-by-case basis, raising the question of whether judicial decision-making powers alone can secure the pre- and post-electoral space. Therefore, I argue for a broader constitutional perspective that recognizes the contribution of knowledge institutions as part of the constitutional infrastructure that protects electoral integrity. So what are knowledge institutions? Vicky Jackson defines knowledge institution as, and I quote, ongoing entities that have as central purpose the dissemination, preservation, or production of knowledge, and that aspire to some degree of objectivity, reliability, or accuracy in evaluating claims and evidence, including the consideration of opposing evidence or views. So, according to Jackson, the legitimacy and proper functioning of democratic systems depend in large part on knowledge institutions. as constitutional democracies require some degree of citizens' involvement, at least to express approval or disapproval of office holders through elections, citizens, both individually and as part of a civic, political, or social group, must have access to reliable knowledge. And this knowledge allows them to evaluate the performance of elected officials, to engage in reasoned debate with fellow voters, and to contribute to the development of public policies that affect their lives and communities. Crucially, this also, of course, requires critical thinking, which equips citizens to navigate complex information and engage responsibly in democratic life. So Jackson suggests that knowledge institutions should be recognized by comparative constitutional law studies as an essential component of the constitutional infrastructure because they act as intermediaries between citizens and information, helping the public to distinguish genuine claims from fabricated ones. And of course, knowledge institutions include universities, the free press, civil society organizations that collect data, and governmental bodies as well. In fact, in the last years, many of these have supported academic research or projects that, of course, track and monitor disinformation and misinformation flows, especially in the electoral field. That being said, courts could be considered part of this category as well. In fact, they develop knowledge in their adjudicative role, but they also disseminate knowledge, promoting the public understanding of the law, both through legal reasoning and educational activities beyond the courtroom. Thus, we could argue that by producing and disseminating knowledge, courts can contribute to the public understanding of electoral procedures and the integrity of the democratic system at large, both within and outside judicial settings. And Brazil experience offers a clear example of how courts can complement adjudication with proactive measures, which are meant to safeguard the informational dimension of democracy. So back in 2009, ahead of the 2020 election, the Superior Electoral Tribunal launched its program to combat disinformation, which acts as a focal point of Brazil's response to false information. And the program works with universities, journalists, NGOs, and of course, digital platforms to provide accurate information on electoral procedures, on voting mechanism, on ballot counting, and of course, on the role and function of the electoral tribunals as well. And to achieve this, the program focuses on three main areas, that is providing accurate information, empowering citizens through media literacy, and responding, of course, to false information, both through corrective and preventive measures. And built on this initiative, in 2021, the Supreme Federal Court launched its program to fight disinformation. Whose main objective is actually to respond to the harmful effects of disinformation that undermine the credibility of the court, that misinterpret the legal reasoning of its decisions, and that attack constitutional principles and threaten the stability of democracy. Of course, we know that in Brazil, those initiatives arose in response of political attacks against the courts, but constitutional and Supreme Courts worldwide often engage in educational activities, which are usually part of larger efforts to clarify legal arguments, to promote and inform public debate, and also to prevent attempts to misinterpret court decisions or undermine public trust in the rule of law. Having said that, while knowledge institutions can play a role in safeguarding the informational environment around elections, those same institutions increasingly face attacks that threaten their independence and effectiveness. For instance, in the US, since 2023, congressional inquiries and private lawsuits have portrayed projects that study and monitor disinformation and misinformation flows as part of the so-called censorship industrial complex. And the Select Subcommittee on the Weaponization of the Federal Government defined this, and I quote, the often interlocking and hidden network of public and private censor who sought to silence protected speech, which of course misleadingly equate disinformation research with governmental censorship. But in the end, these attacks delegitimize researchers who study conspiracy theories and their effects on the democratic system, and they do that on the basis of unfounded claims. Most importantly, courts can also get caught up in these narratives. In Murphy versus Missouri, the lower court judges accepted the plaintiff's claims that the Biden administration had pressured social media companies to suppress content in violation of the First Amendment. And although the Supreme Court dismissed the case for lack of standing, Justice Barrett, who wrote the majority opinion, pointed out in a footnote that the findings by the lower judges were erroneous and also provided many specific examples in which the lower court had relied on allegations rather than facts. Of course, we know that pressure on knowledge institutions are visible well beyond the US. I don't have enough time to delve into that, but I think it is worth mentioning the case of Hungary, where we know academic freedom has been greatly undermined since 2018. So back in May, Fidesz presented the Transparency in Public Life Bill ahead of the 2026 elections, and the law would empower the government to monitor, punish, and potentially dissolve organizations that receive foreign funding and are considered a threat to Hungary's sovereignty. And of course, critics argue that the law would limit investigative journalism and civil society oversight and will reduce the access to knowledge and reliable knowledge and the ability to monitor electoral integrity. So to conclude, as Ginsburg and Huck have observed, the practical operation of liberal democracy requires a shared epistemic foundation. Where information is systematically withheld or distorted so as to engender population-wide errors, democracy cannot fulfill this epistemic mandate. And in fact, disinformation erodes that foundation through multiple channels and actors, hybrid operation by foreign powers, traditional and new media outlets, and of course, political leaders who lend institutional weight to disinformation narratives. And overall, these dynamics weaken citizens' capacity to make a free choice and undermine their trust in electoral procedures and electoral results. So against this background, knowledge institutions can play a proactive role in preserving this informational core. By producing, validating, and disseminating reliable knowledge, they create the condition under which free and fair elections can occur. And in order to do that, they must maintain independence, methodological rigor, and openness to having their own assumption tested against evidence. Yet these institutions are under attack, and what I want to point out is that those attacks not only threaten their independence, but the very democratic system they support. In fact, scholarship highlighted that in countries where authoritarianism is rising, attacks to universities, NGOs, the free press are accompanied by attacks to judicial independence, watchdog governmental bodies, and free and fair elections. So I think that further research should explore how constitutional design can protect these epistemic infrastructure and also way for courts to foster collaboration with other knowledge generating bodies. Thank you.
Thanks so much, Dakele, also for this focus on knowledge distribution and for presenting a broader perspective, especially in this period in which universities, among other things, are under siege. I think it's very important. Okay, so now the next speaker, the next presenter is Dragos Kalin, who is the judge at the Bucharest Court of Appeals and co-president of the Romanian Judges Forum Association. Is going to present a paper entitled "Should We Save the Rule of Law by Temporarily Undermining Its Guarantees?" Question mark. You have a PowerPoint presentation. Let me help. I think that it's okay. So it's already ready where you are.
Thank you, Giuseppe. According to Venice Commission, the power of constitutional courts to invalidate elections ex officio should be limited to exceptional circumstances as ultima ratio, and on the condition that irregularities in the electoral process may have affected the outcome of the vote. On the other hand, the European Court of Human Rights and the Venice Commission both indicated the choice of offering fresh election by law as mitigating the gravity of an annulment. And we have this judgment, decision 32 on 2024 of Romanian Constitutional Court, most likely based on the existing legislation in Romania. However, some very important aspects related to democratic principles at European level were either disregarded or insufficiently justified. And this judgment was indirectly criticized by the Venice Commission. We have this urgent report on the cancellation of election resulting by constitutional courts. In the opinion of the Venice Commission, such decisions should precisely indicate the violation and evidence, and they must not be based solely on classified intelligence, which may only be used as contextual information, as this would not guarantee the necessary transparency and variability. In Romania, we have the legislation, the functioning and the powers of the Constitutional Court, not sufficient clear. But on numerous occasions, the Constitutional Court of Romania has established its own powers by virtue of its role as guarantor of the supremacy of Romanian Constitution. So this is not a problem. But at the same time, the ex officio judgment was essentially based on intelligence services reports, and the interest parties were unable to defend themselves during the procedure, and the effects over time reflect a clear deficit of democracy. This is very important, the clear deficit of democracy, because this is the Venice Commission that noted that. Extrapolating, the European Commission is largely to blame for the democratic deficit in Romania, because, for example, in 2022, the new laws of the judiciary in Romania created an obedient body of judges in which the quasi subordination of judges to court presidents is defining. But the European Commission accepted that because of the war in Ukraine. On the contrary, the Commission repealed the verification and cooperation mechanism. Romania and Bulgaria were under this cooperation verification mechanism. And in fact, in this case of Romanian election, Romania's failure wasn't the court's timing. It was the broader system inability to act before the crisis. Because the constitutional courts can intervene, but after damage is done, proactive defenses require the combined efforts of lawmakers, electoral commissions, and international cooperation to address vulnerabilities before they are exploited. In Romania, public opinion has doubts about the existence of those secret documents related to Russian interference, but the former US ambassador to Romania stated that there is multiple evidence which the Romanian public does not suspect, and this practically refers to American aid for the Romanian intelligence services, and of course the French Service for Surveillance and Protection Against Foreign Digital Interference, Viginium, published a report in February 2025, and it's clear that the campaign was based on the one hand on the coordinated action of networks of accounts, and on the other hand on the exploitation of the popularity of influencers who were secretly paid. And we have the same opinion of NATO in July 18, 2025, and the Council of European Union in July 18, 2025, saying that Romania attributed a sophisticated hybrid attacks that significantly impacted its electoral process to Russia. So my idea, it is very possible that accepting a democratic deficit to save democracy will become a principle in the coming years, both in constitutional law and for the Venice Commission, and of course for the Court of Justice of the European Union. This idea of accepting a democratic deficit to save democracy suggests a trade-off where some perceived democratic shortcomings are tolerated or even embraced to preserve the overall democratic system. And this can be a complex issue with various perspectives, but generally involves prioritizing the stability and functionality of democratic institutions over strict adherence to democratic ideas in specific instances. And in the context of the European Union, the concept of democratic deficit is discussed frequently. Accepting this kind of democratic deficit involves knowledge that certain aspects of the democratic system may be not perfect, democratic, but choosing to tolerate or even prioritize other factors like stability, efficiency, or national security. And of course, it was the case of COVID-19 pandemic and some short time democratic deficit in all the countries of the European Union. We have some arguments for accepting a democratic deficit. For example, stability and security is logical. In time of crisis, a democratic deficit might be seen as necessary evil to maintain stability and security. We have efficiency and expertise. And we have, of course, pragmatism, because in some complex system like the EU, it might be necessary to accept some level of democratic deficit to make the system work effectively. But of course, we have some arguments for against accepting a democratic deficit. And of course, erosion of democratic principles. Tolerating democratic deficit can lead to a gradual erosion of democratic values and institutions. We have the lack of accountability, because concentrated power in the hand of unelected officials or bodies can lead to a lack of accountability and transparency. And we have potential for authoritarianism, because accepting a large and unchecked democratic deficit can create conditions that are more vulnerable to authoritarianism. In such circumstances, starting from the Romanian example, the discussion is not exclusively related to the proportionality of the involvement of constitutional courts, but to the means that they have at their disposal to prevent catastrophes in the electoral process, because it was a kind of preventing catastrophes in democratic process in Romania. So the adaptation of the legislation of democratic states in this regard seems imminent and vital for preserving the rule of law. What is preferable? A democratic deficit in the adoption of a decision? It was the case of Romanian Constitutional Court, or the gradual loss of the rule of law through rigid election influenced by powers hostile to democracy, like Russia tried in the case of Romania? Because the answer is logical, is obvious, with all the nuances that can be created. And the decision of whether to accept a democratic deficit to save democracy is a complex one with no easy answers. It requires careful consideration on the specific context, the potential benefits and risks, and the long-term consequences for the democratic system. While some degree of pragmatic compromise might be necessary in certain situations, it is crucial to remain vigilant against the erosion of democratic principles and to strive for a system that is both functional and truly representative on the will of the people. Thank you.
Thanks so much, Dragos. You managed, to present in an impressive manner a really complex set of things in 8 minutes. So you are my hero. And you do also, in your speech, you also managed to deliver this message. In democracy, there are no easy choices. And sometimes we have to go beyond the mere balancing. Balancing properly understood, it implies the possibility of preserving the core of two competing goods. Here, we are instead talking about dilemmas in which you have to actually lose something, perhaps. So thanks so much. It was a brilliant presentation. And now I give the floor to Lorenzo De Carlo, who is a PhD researcher, a PhD candidate in law at the Sant'Anna School of Advanced Studies, here in Pisa. He's going to speak about the constitutional courts, electoral authorities, or domestic jurisdiction, the question mark, evaluating the outcome of French, Spanish, and Italian models when facing challenges to election integrity. The title is a bit long, but I'm sure that they will manage to deliver in 12 minutes.
Thank you, Giuseppe. Hope you can hear me properly. Okay, my relations will talk about a peculiar system of electoral justice, which is the Italian electoral system of electoral justice. What I'm hoping to analyze is these questions. Is the Italian system fair and up to date? It's a very peculiar system. It's based on self-jurisdiction, and it's almost unique in Europe right now. Are there any chances of improvement that can be offered by the comparison with other systems like the French and the Spanish one? These are two systems that, despite the significant differences, have moved beyond or have never adopted this model of self-jurisdiction. And at the end of the relation, I will be asking myself, are these transplants feasible? And if they are feasible, would they work in the current legal framework? Starting with the Italian Constitution, the Article 66 states that each chamber shall judge of the parliament, clearly, shall judge the qualification for admission of its members and for supervening causes of ineligibility and incompatibility. This is the establishment of the principle of autodikia. It's a Greek word. It can be translated as self-jurisdiction, and it wasn't an innovation of the Constituent Assembly, but it was a direct legacy of the Article 60 of the Albertine Statute, former Italian Constitution of 1848, at times of even before the unification of the country. The original rationale of this provision was clear. It was to defend the independence of Parliament from possible interference by the executive branch, originally also by the king. At the time, the king and the government held significant influence over judiciary power. So it was crucial to defend the members of the parliament even after before and after the election, during campaigns, but also after the proclamation of results from possible interference. What these guarantee during with the years passing has crystallized into what some part of the scholarship has defined a zone exempt from judicial review, in Italian zona franca. For decades, all the conflicts, all disputes concerning House and Senate elections, both in the preparatory phase, so like admission of symbols and the lists, and the phase following the proclamation of results by the Central Electoral Office, have fallen almost exclusively under the purview of the chambers, chamber deputies, and the House and the Senate. And this has created a dual-track system. And from one side, the local, regional, and the European elections. Here, citizens and candidates enjoy full protection before administrative or civil courts. While for parliamentary elections, this protection is absent, almost absent, and there is a clear conflict with the principles of effective judicial protection, which is enshrined in Articles 24 and 111 of the Constitution. The Constitutional Court has safeguarded this view, but recently has started showing some impatience with this lack of protection after years of a cautious approach. The real turning point has come with the judgment 1 of 2014 and 35 of 2017, in which the Italian Constitutional Court have definitely dismantled the dogma of the exemption of the exempt zone, the free zone from the scrutiny of the Constitutional Court with regard to electoral law. And it has affirmed its own competence to review the constitutionality of electoral law. And with judgment number 48 of 2021, the court has issued an explicit and not an unambiguous warning to the parliament. It has highlighted the need to provide an ad hoc procedure for pre-electoral justice, which is the most crucial phase, which is basically lacking any judicial protection. Because the pre-electoral phase in Italy is provides just some guarantee by administrative bodies like regional and central electoral offices. Times for the electoral calendar is quite packed and tight. There is very little time between the indication of the election and the day of in which the polls open. So it's necessary to be quick and always, and in the majority of cases, the judicial system doesn't have the time to process all the claims. And this anomaly has been highlighted by the Venice Commission too. The Code of Good Practices in Electoral Matter provides that even where, like in Italy, parliaments act as a first instance adjudicator, and in Italy it's not a first instance adjudicator, it's for the post-electoral controversies, it's the only one and only adjudicator. In any case, a second instance appeal to judicial body must be guaranteed. The problem is that this does not happen in Italy, also because the Constitution, Article 60, provides this self-jurisdiction, and that has been interpreted like total self-jurisdiction after the election, the proclamation of results, and before that, like it's there is a lack of protection, and these issues have become more critical since Italy has Italian electoral law has introduced single-member constituencies, like in the US or in the UK, because in some cases, when the recount is entrusted to a committee, internal committee of the parliament of the chambers, it has happened that if the margins between the two candidates are very narrow, the political side of the question emerges, and in top when it comes to recount, when it comes to adjudicate over the validity of some polls and ballots, political arguments and political and partisan logics emerge and undershadow impartiality and third-party status of the committee. If we turn our look from Italy to other countries, our picture changes radically. In fact, France has made a total break with its tradition of self-jurisdiction with the Constitution of the Fifth Republic in 1958. And this was mainly due to the notorious annulment in 1956 of the election of 11 deputies from the Pujadist party, anti-system, essentially right-wing party, and they were replaced by members of traditional parties. It was considered an abuse of power by the majority against a minority. And so the role of electoral judges, especially for presidential elections, has been entrusted to the Conseil Constitutionnel, the organ of constitutional justice. So the Conseil oversees all the regularity of the whole process, examines all the complaints, and proclaims the results. And this jurisdiction spans both pre- and post-electoral disputes. There are it's a mechanism to ensure fair elections and reduce partisan interference. Nonetheless, there are some perplexed about the composition of this body, especially when it has been called to adjudicate cases with strong political impact. Let's think about a case of Sarkozy, case of Le Pen. And in general, it's true that its members are politically appointed, even though when it acts as an electoral judge, the composition is enhanced with technical rapporteurs from Council of State, so experts. The decisions try to respect the will of the electorate. As a rule, if there are serious irregularities, the Conseil does not rectify the result, but annuls the election and calls for a new vote, even in one town or one constituency. There have been emblematic cases, such one of during the second round between Chirac and Le Pen, a mayor of a little town who installed decontamination devices in a polling station, and it was annulled because it violated the regularity and the seriousness of the election. In another case, in a little town of 30, a population of 30, they voted in a church, and it was annulled exclusively there exclusively in that town. While the Spanish model does not entail any self-jurisdiction, but the system is not centralized. It's based on a plurality of organs. Among them, the main role is played by the Administración Electoral, which is an independent administrative authority based on the juntas electorales, central, provincial, and local juntas that are composed by both judges and university professors of law and political science. This model guarantees a very high degree of impartiality and expertise. Moreover, the decisions of the juntas are not final but can be appealed before the administrative courts. And for the violation of fundamental rights, even in the electoral matter, the Tribunal Constitucional can be approached via a recurso de amparo electoral. And this is aimed at ensuring a full and complete, multifaceted protection to the rights. So, to conclude, what future for Italy? We have to divide between pre-electoral disputes and post-electoral disputes. Pre-electoral disputes are inevitable. The path is clear, giving it to administrative courts, extending their exclusive jurisdiction to all preparatory acts of elections, and to introduce a fast-track special procedure with strict deadlines in order to get to some quick decisions. At the same time, the post-electoral disputes, neither the French model and the Spanish model are efficient, in my opinion, because from one side, the Italian Constitutional Court is not a technical body. It's a judge of laws, not a judge of facts. Entrusting it to the function of checking every single complaint, even little complaints, would distort its function and expose it to enormous litigation. At the same time, an ad hoc body would be quite fascinating, but it would be crucial to save its independence and guarantee the competence and maybe selection by draw of its members. So I'd suggest the extent of the jurisdiction of the administrative courts even to post-electoral disputes, but with a revision of the constitution, because at the moment it would be hardly compatible with Article 66. Thank you.
Thanks indeed, Lorenzo, also because you went beyond the usual suspects. Now, we have so far, covered many interesting jurisdiction, but it is the first time, apart from a part of the speech given by Matteo Monti, that we touch upon on other jurisdiction. Thanks indeed. And now I give the floor to Dr. Daniela Dobre, who is a postdoctoral research fellow at the University of Granada, and also she's also doing research currently at the University of Rome Tor Vergata. She's authored of a very recent book, which I do recommend. She's on the independence of the European Central Bank, and she's going to talk about shaping democracy through judicial statecraft, the evolution of the Romanian Constitutional Court. You have a PowerPoint, I guess. I think it's everything is in order as always, and I give you the floor. Thanks so much.
Thank you, Professor Martinico, for such a kind presentation. And I would like to dedicate 10 seconds to thank very much to Professor Sperti and Rachele Bizzarri for the opportunity to be here today. Can you hear me well? Okay. So my presentation titled Shaping Democracy Through Judicial Statecraft, the Evolution of the Romanian Constitutional Court, will be structured in 5 parts in order to fit the time requirements. I will begin by briefly situating constitutional courts in post-war democracies and the institutional context of the birth of the Romanian Constitutional Court. Then I will introduce the theoretical lens of judicial statecraft proposed by Rosalind Dixon. Then I will outline the research questions, and the core research will focus on 3 key decisions of the Constitutional Court, which will allow me to extract some findings in terms of strengths, weaknesses of the jurisprudence of the Court of the Romanian Constitutional Court, also from a comparative perspective. So, see if I, okay. So, as it is well known and was also widely discussed this morning, constitutional courts are inherent to post-war constitutional democracies. And in Central and Eastern Europe, they emerged in the 90s as a structural part of the democratic transitions, also as a means to consolidate fundamental rights and separation of powers. In Romania, importantly, there was no legal tradition of a centralized review of legislation before the 91, and the Constitutional Court, from this perspective, may be described in words of former constitutional judge of the Court of Italy, Enzo Kelly, as a court without a history. In the same vein, the institutional legitimacy of the Constitutional Court of Romania had to be constructed from scratch. Importantly, as I said, in a legal order unfamiliar with centralized constitutional adjudication. So, indeed, the democratic transitions in these countries, as I said, were closely linked to constitutional mechanisms designed to strengthen the separation of powers and protect fundamental rights and democracy. And in this regard, constitutional courts were entrusted not only with the counter-majoritarian role of reviewing legislation, but also with the so-called ancillary tasks, such as verifying presidential electoral results. However, these competencies also extend the scope of constitutional adjudication beyond the traditional boundaries, raising questions about the role of these courts in democratic consolidation. I always go back instead of, okay. When we arrived to the Constitutional Court of Romania, it's important to know that it was established in 92 to guarantee the primacy of the Constitution and also somehow to consolidate Romania's democratic credentials. Yet, it also had to construct its own legitimacy within a legal order that was historically marked by an openness to constitutional justice, indeed, but as I mentioned, until the entry into force of the 91 Constitution, there were this openness to review of legislation was not institutionalized in a centralized form. Also, a legal order marked by a general distrust towards the judicial power. And the court, at the same time, had to insert itself in a legal order that aspired to align with the Western model of constitutionalism. To analyze the Constitutional Court of Romania, I draw on Rosalind Dixon's concept of judicial statecraft, understood as the court's approach to timing authorship, narrative, and its engagement with political and societal actors. Interestingly, this concept switches the view from the institutional context to the way in which the court itself behaves, so to say, through its decisions and judgments, aiming to produce a consolidated and effective jurisprudence as a strong court. Thus, creating, and I quote from Rosalind Dixon, a wide-ranging legal and constitutional change. This ultimately would create so-called peculiar institutional strength of the court, deriving from within rather than from its external institutional context. According to Dixon, strong courts use so-called techniques of judicial statecraft and strategically shape democratic trajectories. And these tools are, for example, democratically sensitive timing, a judicial voice that speaks directly to the losing party in the case, a narrative that combines global and local elements, reasoning that shows a posture of respect towards the losing party, or engagement with civil society and the government, considering these as actors that are partners in the implementation of the constitutional requirements. By contrast, weak courts are less sensitive to these factors. So in the paper that I will produce after this workshop, that is a work in progress right now, I aim to ask two main questions. The first one, to what extent does the Constitutional Court of Romania demonstrate features of a strong judicial statecraft in its constitutional adjudication? And secondly, how do institutional design and historical context shape the court's capacity to contribute to democratic consolidation? As I mentioned in the beginning, my analysis will focus on three key decisions of the Constitutional Court. The first one is a very early, in very early times of the court in 2005. Here, the court aimed to define for the first time the concept of emergency in legislative delegation, although in the end, despite this good intention, in the end, one reaches the conclusion that the definition is quite circular. Then I go to a decision in 2010 dealing with pension cuts amid the financial crisis, and this remains relevant still today. I could underline at least two reasons. First reason, due to requirements from the EU to strengthen fiscal sustainability of Romania, and more contingent considerations, because right now Romania is going through some political instability in terms of fiscal measures that have to pass. Right now, the review of the Constitutional Court, and the Prime Minister is saying that he's going to quit if these measures do not pass, so to say, the Constitutional Court. And then, of course, I also include the 2024 decision on the annulment of the presidential elections. Here, I will add no further words because I think enough has been already highlighted, and better than I could do it myself. But I would like to point out that in this analysis of the three decisions, I would like to also highlight that procedural instruments are also relevant for measuring the court's statecraft, because it's not the same, of course, if it's an ex ante review of legislation, an ex post, or even an electoral procedure. And in these procedural instruments condition the timing and the matters that the court can reach with its constitutional interpretation. And importantly, this is very relevant, especially for the ex ante procedure, ex ante review of legislation that was mentioned also in the morning. And some authors in Romania are even mentioning that this procedure should be expelled from the jurisdiction of the court, because political opposition uses this instrument in order to block legislation, basically. In any case, in terms of initial findings, these case studies allowed to conclude that. Can you hear me? The court at times has displayed some democratic responsiveness and constitutional innovation, as shown in its intention to defend the democratic electoral procedure, or its intention to define constitutional limits for legislative delegation and to define the notion of exceptional cases. However, so these moments indeed reveal a potential of the court as a strong court in terms of Rosalind Dixon's scholarship. However, while this potential is highlighted in the same decisions, the court often relies on formalistic reasonings and, importantly, lacks strategic use of timing or narrative and remains vulnerable to political pressures. And these are attributes that are also associated with a court that is still in need to build the so-called strong judicial statecraft. So to conclude, because my time has passed, I have to skip the comparative perspective, but just to briefly mention that when put in comparative perspective, these case studies show that these are dilemmas that are common to post-communist countries, but with the specificity of the Constitutional Court that I mentioned, that lives in a legal order that has no tradition for centralized review of legislation. And this element, I think, is very important when one approaches the court. As a conclusion, the Constitutional Court stands at the crossroads between innovation and vulnerability. And as Romania faces economic constraints and political contestation, the court's future, I think, the court's future role will depend on whether it can move beyond formalism and beyond constantly overlooking issues of political constitutional timing and narrative towards a stronger judicial statecraft, combining constitutional interpretation with strategic judgments to safeguard democracy in times of crisis or democratic regression. Thank you for your attention.
Thanks to Daniela for offering a fresh perspective on this national case, thanks to also the seminal works by Dr. Dixon, duly used and developed. Thanks so much. You don't. Okay, so now I give the floor to Alina Doven, who is based at the University of Trento, and she's a postdoc fellow at the University of Trento, and she's gonna talk about the powers of the Constitutional Court of the Moldova in the electoral processes, Pandora box. You have 12 minutes. Ready where you are. Thank you.
Dear colleagues, good afternoon. First of all, I would like to thank you for the invitation to participate in this workshop. It's my first time at the University of Pisa, and it's a great pleasure to be here with all of you. I'm a Ukrainian public law scholar, but my report is devoted to Moldova. About Moldova, it was told a lot during this morning session, as it was emphasized by our colleague. In few days, there will be parliamentary elections, and from the geopolitical point of view, of course, this event is of great importance, especially for Ukraine, because Moldova is a small country with a population of only 2 million of people, and it's situated between only two states, Romania and Ukraine. And from this point of view, of course, and in terms of war in Ukraine, informational, let's say, disorder or chaos now in social networks, for example, in Telegram, this event should be monitored, of course, from the legal point of view. Having analyzed the electoral powers of the Moldovan Constitutional Court, it could be said that who has any influence on the Moldovan Constitutional Court has a power in the country, because the electoral powers of this constitutional court is are really amazing, because they are so wide that it could be really a Pandora box, and if to use the situation from the point of view of pro-European or pro-Russian situation. So as for the Moldova, it's as you all know, it's a post-Soviet country, and it's one of the country of so-called term used by European Commission trio countries. It's Georgia, Moldova, and Ukraine. All these three countries we're moving to the European Union. However, it could be said we have already lost Georgia, and this way who decided to stand aside of the process of European integration in war. Ukraine is in war, and now we're looking at Moldova, what will be in this country. In 2022, the Republic of Moldova was granted the European Union candidate status, and in 2023, the accession negotiations were opened. It is worth mentioning that it's interesting that in European Commission's opinion on the Republic of Moldova application for membership of the European Union, it was stated that the Constitutional Court of Moldova was recomposed in 2019 and is now independent. However, in few days we can see whether it is true or not, because to my mind, I think it will be another test for independence for the Moldovan Constitutional Court. It was mentioned in this European Commission's opinion about the events of 2019. It was a huge constitutional crisis in Moldova provoked by the Moldovan Constitutional Court, who was absolutely politicized. I was thinking that only our Ukrainian Constitutional Court is absolutely politicized, but no, Moldovan Constitutional Court is also in our, let's say, team of politicized constitutional courts, but I think it's a reality of all post-Soviet countries, unfortunately. So in 2019, it was a constitutional crisis, and I found an interesting article published by Torbjörn Jagland in New York Times, and he named them. He called Moldova as captured state that should be returned to its citizens. So the crisis was so deep that even it was used such a term as a captured state. So about Constitutional Court, it was established as in most post-Soviet countries in 90s. In Moldova, it was in 1995. It's rather small. It's only 6 judges in this Constitutional Court, but the population is it's a small country. Its population is only 2 million people. That is why, of course, it's only 6 judges. What is interesting? The country is really preparing for something what could happen in few days and few weeks, because in April a new law on the Constitutional Court was adopted. In August, I will just repeat that there are only 6 judges in Moldovan Constitutional Court, and in August, it's interesting that 5 judges, their term of powers were expired simultaneously in 1 month. So they were 3 of them were reappointed, and new 2 judges entered the Constitutional Court. So it was recomposed, let's say, but the head of the Constitutional Court of Moldova, her surname is Manuka, if I pronounce well, and it's interesting that she was in the political party presented by the present the current president of Moldova, Maia Sandu, so it could be considered to be also politicization of the Constitutional Court. As for the powers of the Moldovan Constitutional Court in the electoral process, why they are so wide? For example, besides, like, let's say, traditional powers of any constitutional court, this constitutional court shall confirm the results of the referendums, elections of the parliament and of the president, shall rule on questions concerning the constitutionality of a political party, shall determine the circumstances justifying the dissolution of parliament, the dismissal from the office of the president. So, as we can see, the powers are really wide, and despite the recommendations of the Venice Commission, which plays really a crucial role in the reforms in all post-Soviet countries, especially, for example, in Ukraine, but also in Moldova, these powers were not limited, but now in this new edition of the law of the Constitutional Court, they are the same. Absolutely nothing has been changed. Moldovan Constitutional Court has been playing a crucial role into the political landscape of this country always. Many its judgments were criticized not only by national but also international experts. Some of them are really interesting. For example, in 2014, a political party, Patria, was excluded by the Constitutional Court from the participation in the parliamentary elections 3 days before the elections. However, in 2000, the European Court of Human Rights held that the exclusion of Patria from the election process was a violation of the European Convention of Human Rights. Another interesting, let's say, from the legal point of view, judgment was held in 2016. Constitutional Court of Moldova ruled that the constitutional amendments made in 2000, so 16 years ago, which introduced the procedure for electing the president by the national parliament, were unconstitutional. So after 16 years, Constitutional Court just decided to review its own decision, held in the almost the same composition. Of course, it's a politicization, it's very clear. Last year, as it was also already mentioned in the morning session, it was a referendum held in Moldova as for the European integration of this country. It was mentioning that it was not supported so much by the population of Moldova. Maybe it's influence of war in Ukraine, because they're close, they see how it's going on. So some of people are rather skeptical about further European integration as well, for example, as in Georgia. And the turnout was really very low. It was 50%, and 50% voted in favor of introducing a provision on European integration into the constitution, while 49.65% voted against. And as a result, the supporters of European integration won by a margin of less than 1%. And after the referendum, the party of communists of the Republic of Moldova. It's interesting that, for example, in Ukraine, this party is already forbidden. In Moldova, for me, it was interesting to know that now they're still even popular among the population, but maybe it's so-called nostalgia, which is well known in all our post-Soviet space. So the Party of Communists challenged the results of the referendum before the Supreme Court of Justice. Members of this party demanded that the votes be recounted, and the petition was accepted, but the Constitutional Court of Moldova refused to consider the party as a party to the process. I'm a very strong supporter of European integration, but from the legal point of view, of course, we need to respect also opposition. But in this aspect, it could be said that it was also a more political decision by the Constitutional Court than the legal. Venice Commission repeatedly pays attention to the risk of courts politicization due to its jurisdiction. It was stressed in all opinions concerning the Constitutional Court and electoral processes. But till now, the situation as for the list of powers of the Constitutional Court has not been changed. So, as it could be seen on the example of this court, of Moldovan Constitutional Courts can both strengthen European Union values, but at the same time undermine it. Thank you for your attention.
Thanks so much, Alina, for bringing the case of Moldova to the comparative law table. I think it's a very important, crucial case, especially in these weeks. And thanks so much a lot. So I'm sure we will discuss your presentation as well. And now I give the floor to Manuel Gierki from the University of Pisa. He is gonna present a paper entitled "Guardrails Under Stress: Brazil's High Courts and the Defense of Electoral Integrity." You don't have a PowerPoint, right?
I don't. Yeah.
All right. So then I'm all in. Please.
Perfect. All right. So good afternoon, everyone. And a big thank you to the organizers and to Circle U for this great initiative. So the work I'm going to present today is based on joint work with Luciano Daros and part of a broader research agenda on the politics of prosecuting and convicting former heads of government, right? So we have data on every conviction around the world, right? And we have been working on projects that try to understand the causes and the consequences of this important and growing phenomenon over the last decades, right? So this includes ongoing cases involving the former presidents of South Korea, Yoon Suk Yeol, and the former president of Pedro Castillo, just to name two, but there are many other examples that have been also discussed today. So in this specific presentation, I will discuss how Brazil's highest courts responded to Bolsonaro's sustained attacks on the legitimacy of the electoral system, right? And the courts themselves, right? So this was a core part of Bolsonaro's strategy, both to get elected, but especially to remain popular once in government, right? But also his attempts and the attempts of people in his government to undermine electoral integrity, including during election day, right? And the actions to prevent the transfer of power. Right, so this reaction, of course, culminated right with Bolsonaro's recent conviction on September 11th of this month, right, for attempted coup d'état, which included a plot to assassinate the electoral president, the elected vice president, and the Supreme Court justice overseeing cases against Bolsonaro. Right, so in this presentation, this brief presentation here, I'm going to try to make sense and understand how did we get there. Right, so how does Bolsonaro, from the presidential office, goes to being sentenced? Right, so this is in many ways a distillation exercise, right, and also serves to complement Raquel's presentation by giving this bird-eye view on the court's actions but it also speaks to many points raised in presentations by different people today. So our argument is that the Brazilian highest courts adopted a strategy that helped contain these authoritarian pressures, right, while reacting largely in self-defense and navigating uncertainty and trade-offs. So the rest of my presentation is structured in 3 points, right? So I'll first illustrate Bolsonaro's attack because not everybody needs to be familiar with this, right? So this is important to understand because this way will allow me to illustrate and detail how the courts reacted to that, right? And then I'll conclude by highlighting some of the trade-offs and some of the things that we can learn also from the Brazilian case and from the election, especially the elections in 2022, that can be useful to compare to other cases that people here are interested, but also to cases in general, right? So in terms of Bolsonaro's attack, right, he followed a similar playbook to what other people have discussed here today, right? So he systematically questioned the electoral system, attacked the Supreme Court and the Electoral Court justices, right? And cast doubt, like an important component was casting doubt on the voting system, right? So this included massive public rallies in which banners and chants threatened justices. And at times, the president himself would label the justices, the Supreme Court justices as cowards or worse things that I won't repeat here, and declared his refusal to abide by the judge's decision, right? So Bolsonaro never had the legislative majority to pack the courts to impeach these justices, like some other presidents in Latin America, but not only, right? In other cases of democratic backsliding that we have seen in the world in the last decades, right? So this attack served 2 purposes, right? So by attacking the courts and the electoral system, this was a very convenient and effective method to mobilize support from the core base of Bolsonaro, right? So, and to help him remain with this anti-establishment character that he adopted despite having been in elected office for 28 years before being elected president, right? And besides being the president himself, he's still trying to portray himself as an outsider, right? But it was also an attempt to protect close allies, cabinet members, and in investigations and in trials, right? So Bolsonaro could afford to do all this because other control institutions, such as the prosecutor general, was very compliant, right? And because of his strategy of engaging elites in Congress, especially after the second half of his term, was very effective because it also gave away a strong budget authority to Congress members, right? And gave them billions of euros in earmarked transfers that they could transfer to their electoral bases, right? So this was part of the deal Bolsonaro did to protect himself from any checks that could be done by Congress, right? So not only that, but there are also many important actions on electoral day that try to undermine electoral integrity. And this includes not allowing voters in the opposition candidate at the time, Lula, right, in the strongholds from reaching the polls, right, by using the federal highway police, right? So even during electoral day, the institutions, the public institutions were engaged in efforts to change the results of the elections, right? And after losing, right, Bolsonaro refused the peaceful transfer of power, never accepted his defeat, right? And there were also many blockings and protests across the country, and people trying to convince the armed forces to intervene and so there wouldn't be a transfer of power, right? And this has been revealed by the many investigations, right, with many details, WhatsApp messages, detailed plans for the coup, right? And the detailed plans for the coup actually, not only declaring a state of emergency, but annulling the election results and replacing the electoral courts, right, with newly established electoral body ruled by military personnel, right? So this was all in the plans that have been revealed by the investigations, right? And you might have seen, right, the pictures or the videos from the attacks on federal buildings on January 8, 2003, as kind of like the last attempt to try to convince the military to intervene. Right, that did not work. So now I'm going to move like how to the courts react, right? And we argued that they reacted in a three-pronged strategy, right? So they did things that constitutional courts usually do, right? So constraining executive initiatives, right? So judicial review of executive aggrandizement and attempts to interfere with electoral governance, right? So this included launching investigations into president allies, right? In terms of disinformation and digital media attacks against the courts, right? And other kinds of rulings, especially by the electoral courts, that were disciplining digital platforms for non-compliance, right? And there was a big fight with some important, influential digital platforms that did not want to comply with the Supreme Court's rulings, right? So the Supreme Court struck down decrees and measures, right, that expanded this executive authority beyond the constitutional limits, right, and was actually acting quite forcefully during the electoral cycle, because it also had learned from the previous election where it wasn't very active, right, and this led. So the electoral courts also ruled Bolsonaro ineligible in 2023, right, for abuse of political power and misuse of state media to perform attacks against the electoral system, right? So, but importantly, not only did the courts constrain executive initiatives by Bolsonaro's government, but it also enabled, and because it was too costly for the constitutional courts to act on its own, right? So the prosecutor general was on Bolsonaro's side. The elites in Congress were neutralized in many ways, right? So the constitutional court could not really take all the costs, right? So the strategy adopted was to empower others to deal with the president, right? So this, for example, happened when it mandated congressional investigations of the pandemic's management, right, during the COVID pandemic, but also empowered governors, right, to act on its behalf. But, and very importantly, was the Supreme Court's decision to clear Lula, right, the former president, of corruption convictions, right? So Lula had been convicted in 2017, right? But then the Supreme Court, surprisingly, and it's of course hard to think of a counterfactual, but probably Lula's convictions would not have been overturned if there was a normal center-right president, let's say, right? It's very hard to think of a scenario in which it would have happened, right? So importantly, by enabling other institutions and Lula as an opposition candidate, right, who coordinate these actions, right? So this was part of the difficult strategy, right, that the Supreme Court faced, but a strategy that has so far worked, right, at least in terms of democracy. So, and it also acts a lot in terms of extrajudicial communication, right? So the Supreme Court justices are very active on the media, and that, you know, we can, like, that's something very controversial, right, in terms of how they've been acting, but they're also trying to signal how far they can go and talk about the consequences that the attacks on the electoral system could have had, right? So in terms of making sense of all of this, right? So the reaction by the higher courts were not really expected, right? So these courts are usually described as courts of isolated islands, right? Because of the individual powers that these constitutional court justices have, right? They have usually portrayed, but when they were under threat, right, it's somehow unified, right? So, and important institutional characteristics of the Brazilian Supreme Court is that it not only has typical constitutional court's functions, but also a criminal court function, right? So it is the court with the original jurisdiction over high officials, right? And the fact that they manage this massive docket was strategically used, right, to initiate and oversee inquiries that in the end managed to constrain Bolsonaro's initiatives. Right. So, and of course, there's like controversial aspects of this, including the self-initiated criminal inquiries, right? Because of the prosecutor general inaction, right? The Supreme Court decided to base on its internal rules, right? So allows inquiries into crimes against the court or its members, right? And combined with the constitutional duty to safeguard judicial independence and democracy, right? So this is how it used its mandate to investigate not only these digital militias attacking the courts and the electoral system, but also other kinds of anti-democratic acts, right? All of this with the trade-off in terms of like accommodation in anti-corruption, right? So this is a court that was quite active, and the previous period in Brazil was there was a lot of activity in terms of anti-corruption, while like when the court was threatened with democracy, right, it decided to accommodate on anti-corruption, right? And this includes the reversals of many convictions, right? So yeah, so the Brazilian dilemma, the Brazilian case highlights some of the dilemmas, right? So how far should the courts go in defending democracy, right? And what should be the safeguards that are in place to also to prevent judicial overreach, right? So thanks a lot.
Thank you. Thanks so much. Sorry for taming your enthusiasm, but it's a really difficult task they want to have. But it is still, I mean, favored than the a possible discussion about your very rich presentations. And now I give the floor to the next speaker, Maximilian Gravunda from the Humboldt University of Berlin. Maximilian is gonna talk about comparative law to prevent and remedy democratic backsliding, question mark. You have a PowerPoint presentation. Okay, it's already, and you have 12 minutes. Thanks so much. Ready where you are.
Could you give me the remote for the... And where do I start the presentation?
I think
with the presenter mode, please.
In this way, you can also use the arrows, I guess.
And can I? Okay. So,
all right. So
okay, perfect. Perfect. Okay. Can you hear me quite well? Okay. Then, first of all, thank you for all this very, very good organization. Thank you for having me. Thank you for providing with food and accommodation. That helps a lot. Indeed, as you said, my approach today is to define on a first step the what EU values as democracy and rule of law means, in order to then for that we after that can discuss on a proper basis democratic backsliding and electoral integrity. From a sectoral perspective, I focus on a different geographical region. I focus on Luxembourg, not really on Luxembourg, but on the whole European Union, as I research the CJEU, Court of Justice of the European Union. I do that by, first of all, I will be introducing a concept of the European law literature that is called evaluative comparative law method. And then I will try to shed new light on two cases that have been decided by CJEU, that will be Republica and Puigdemont. Can I first of all ask you, are you familiar with either of these cases, Republica, or you have heard of them? Some have, some have not. These are in EU law that they are considered quite important cases. I will get into that. Okay, this is not working. I am using it. But... This is working. Okay.
You have
so this is
one.
Yes, I tried. Okay. Okay. So the concept I mentioned, evaluative comparative law, dates back to the 1950s. It is a concept originating from German scholar Konrad Zweigert. You might have heard of him from the functional approach of comparative law. And the essential idea is that CJEU, this idea was leveled to the European Union level, tries to find the best solution that exists among the member states. I also tried to fake that in Italian. That is at least the official translation used by the court's translation service. Esame comparativo I parametri di valore. And the central word in that is valore, or evaluative, or in German wertend, wertende Rechtsvergleichung. And the classic example you will hear about that is the Mangold decision, which is even more important than the ones than the two I already mentioned. And in Mangold, CJU found a principle of a general principle of age discrimination, but based only on that being found in Germany and in Sweden. So you can really not speak of a general principle, but you can speak of a general principle if you are CJU and pick the best solution, or what you think is the best solution. Now, the first step the first idea I want to introduce is that this so far is not at all linked to the values of the European Union, which is interesting, but has a clear reason. The approach by Konrad Zweigert is just older than the values of the European Union. But I noticed that from the term, in all languages, you have a certain similarity of when you speak of values of the European Union and evaluative approach. And that works only in German when you have Werte and wertende Rechtsvergleichung. And I assume it also works in Italian. I can say that it does also work in French, and then in the others. I didn't assess all of the 27 member states, but it works in the major languages. The two values I would like to focus in that article are democracy and rule of law. Also, these are, to my view, the most important articles when it comes to democratic backsliding and electoral integrity, especially democracy. One note to how I proceed methodically. When I do research comparative law, I do not only read the CJU decisions, but I also focus on the internal documents that are preceded by CJU's comparative law research division. That is a very much unknown unit within CJEU that is carries out comparative law research notes based on requests of the deciding bodies. To this date, there are around 1,200 comparative law research notes, 60 of them being published. They are not linked to decisions, and they will have different names than the decisions, and this is, to my view, the reason why nobody reads them. I think, and I will argue, that it is necessary to read them indeed. For that, I have two examples, the first being Republica, as mentioned. Republica is known for many things. For example, CJU establishing the general prohibition of non-regression. But let me briefly explain what happened in the case. To quote the CJU, the problem was that the Maltese prime minister had something to say in the decision process or the naming process of Maltese justice and justices. And it had some decisive power in renaming them. And so we have a question of the rule of law here. Is it proper that we have such a mixture of separate branches of government when a part of the executive is highly influential in naming or appointing judges and justices? The decision is very well known. The comparative law research note, which has around 300 pages, is not known at all. So note that it's very much longer and more extensive than the actual decision. In that research note, in that internal research note, the scientific service found a spectrum of models, indeed ranging from different branches interfering with the process of naming justices, also with decisive elements of the executive. It also found that in many jurisdictions, independent bodies of the judiciary are involved as on a basis of counseling this executive involvement. And so this is true for the Maltese example as well. To my view, this renders the decision of the CJU, who uphold the Maltese mechanism, in a very interesting light, because I would say the CJU basically looked at what the other member states did, and then as they found that other member states also allow for other branches to interfere with the appointment process of justices and justices, that it is indeed okay for the Maltese Prime Minister to name or to appoint justice and justices. The second example is somewhat different. Now I only see my notes here. Okay. You may know this guy. This is Charles Puigdemont. He was elected member of the European Parliament in the election to the European Parliament in 2019. He was elected indeed, but restrained from exercising his mandate in the European Parliament, which is distinguishing something that is, to my view, not really distinguishable, because how can you be a member without a mandate? It's like completely empty. He was not able to vote. He was not receiving his funds. The reason for the European Parliament to deny Puigdemont from participating in the European Parliament, even though he was a member of the European Parliament, is that there was a Spanish interference with the result of the election. Spain required all his or its members of the parliament to swear an oath in person in Spain to the Spanish constitution. And unfortunately, as Charles Puigdemont is facing prosecution in Spain for rebellion, he cannot swear that oath. He tried to do that by an advocate. He tried to do that from Belgium, where he lives right now, but Spain wouldn't accept that, so Spain wouldn't appoint him to the European Parliament. Again, there's a comparative law research now that compares the situation in the different member states and shows that the CJU was not really clear on how to deal with this situation. And now, interestingly, the comparative law research now reveals that Spain is alone in this mechanism, that no other member state requires its members of the European Parliament to swear an oath in person to the national constitution. There are mechanisms that require the members to swear an oath in national elections to the national constitution, but not in the European elections to swear an oath on the national specific constitution. Now, there were some mechanisms or some requirements of the national members of the member states to accept the mandate, for example, by a writ, but no real proper hurdles. Even though CJU in different decisions uphold the decision of the European Parliament and, to my view, neglected the proper comparative law perspective. I would argue that this is basically based on a misunderstanding of the quality of the different requirements of the member states. As I mentioned, CJU found, or the comparative law division found, that there are indeed national requirements in order to participate in the European Parliament or in national elections, but no other member state required the European members of the European Parliament to swear a national oath in person. I would argue that CJU misunderstood or confused this, to me, crucial distinction, and therefore still followed a specific comparative idea, but maybe not the perfect one. That brings me to a conclusion. Still not. I'm not to you. It doesn't really matter. It's just not working. First of all, I would argue that it is would be very helpful to read the comparative law research notes of that are being manufactured in order to properly understand CJU's decisions. The reason why they are not read is basically that they weren't published yet and that they are not linked to the decisions. So it's basically just hard to find them. But even though they are nevertheless relevant for this. This is my advice or suggestion for lawyers who study EU law, and the conclusion that I draw to the CJU itself is that it uses comparative law research notes internally in order to define the very concepts of democracy and the rule of law, and it could use it more offensively towards the outside, towards the addressees of the judgment, to defy these concepts. And that is how I'd like to end. Thank you for your attention.
Thanks, Maximilian. I think it's a very interesting research. Indeed, as you said at the end of the presentation, the problem is that very frequently this kind of the comparative law analysis is not carried out in an explicit manner, looking at the judgments of the Court of Justice, and that's why we have to go through, these documents and the opinions of Advocate General, which are instead very rich in references to comparative law. Thanks so much. And now I give the floor to Chiara Spiniello, who is a research fellow in political science at the University of Salerno. She's going to present a paper entitled Guardians or Sovereigns, the Militant Democracy Paradox in Constitutional Court Practice. You have 12 minutes, ready where you are. You are going to use PowerPoint, huh? All right, so see again. The computer is stuck, but let's see. I think it's a signal. We have been presenting beautiful research, but we have to. Okay, so you do have a PDF apparently, right? Okay, so do you want to move here? Is it better? Do you want to stand as you prefer?
It's okay. Vedo, eh? No, perché potresti condividere.
Tu sedere? Nobody knows how to share a PDF file. Let's see. We trust you, Maximilian.
Okay.
We are in your hands.
I can stay here, maybe.
Do you want to stay here, Chiara? All right. Please.
It is working. Okay.
Are you sure?
Yeah, yes.
All right. So then you have 12 minutes.
Okay. Thank you, Professor Martinico, and thank you, Professor Sperti and Rachele, for welcoming me and giving me the opportunity to share my work today. My paper asks a simple, not so simple, question, that is, how far can Constitutional Court go when they step into election or when they reshape electoral law in the name of so-called militant or protective democracy? The classic idea of militant democracy is associated with Carl Stein, and it is very easy to state. When political actors try to undermine a democratic order, the state may fight back, even with measures that are not fully democratic. To use outer word is something similar to fight fire with fire. Today, I will not reopen the full theory. I will not talk about the limit that several scholarship has landed about it. What matters for me is what happened when this logic is applied to election, which are the core of modern democracy, the place in which representation, legitimacy, and government are produced. In sum, if there is a real test for any claim to defend democracy, this is it. I must admit my position is rather critical. Bringing militant democracy logic into the electoral moment, into rules, timing, procedures, creates a serious risk. It can shift the center of power away from voters. I'm not saying courts may never act. I'm saying that if they do, they must meet very strict conditions. A clear legal basis defined in advance, strong and challengeable evidence, and proportional remits with a clear preference for less intrusive option. To make this concrete, I consider three cases. Romania's 2024 presidential election, Italy's 2014 and 2017 ruling on electoral law, and Poland's 2016 and 2011 ruling on local election. I start with Romania. As we heard this morning and before, in December 2024, the Constitutional Court annulled the first round of presidential election due to significant violation of electoral campaign online and possible external interference. The constitutional cost of these moves is obvious. The court interrupts the normal electoral processes. It affects the position of voters who have already voted, and it exposes itself to charge of replacing political authority. Moreover, there are also some procedural concerns. The decision did not follow the ordinary timeline set by law for election remits. It comes ex officio, outside a typical proceduralizing activation, and it does not ensure due process guarantee. So also, even if we accept the aim, that is the protection of the authenticity of the competition, the essential condition that must be respected for the use of exceptional measures are not present. A clear legal basis, a strong evidence, and also the proportionality of the remedy. Moving to Italy, Italy comes into focus for a different development. The Constitutional Court in Italy never stopped the election, but in 2014 and 2017, it corrected the electoral law, thereby offering a structural protection for equality of vote and representation. Did it work? In many respects, it did. It removed distortion, forced Parliament to realign law with constitutional principles, and preserve continuity in the democratic cycle. But also in this case, there are some problems. One in particular. In moment when Parliament is inert or delegated, it is the court's judgment that in practice determine the electoral architecture. And this cannot be acceptable at constitutional ground because it gradually weakens Parliament political responsibility for the design of the system. Moreover, both cases raised procedural concern. In particular, in 2017, the ruling reviewed an electoral law that had not yet been applied. That depart from the ordinary Italian model, where constitutional review comes after the application of the law and not before it. So, also in this case, there was and there is a legitimacy deficit. Coming to Poland, Poland is my third reference. Here, the tribunal mostly worked on rules, not by stopping election. In 2006, it looked at change to the local election, especially the list blocking device, and said they were constitutional since the tool was open to all. In 2011, on the other hand, it checked the new electoral code and upheld for local election proxy voting and postal voting, limiting, on the other hand, other typology of solutions, such as the two-day voting at national level. So, in this case, we have ordinary legality, predictable procedures, and no suspension of vote. This can work, but only if judicial independence is strong. Otherwise, this kind of frame control loses effectiveness, both effectiveness and legitimacy. From these three cases, three questions follow. First, the threshold of compromise. Who decide when electoral competition is irreparably altered? Saying the court decide is not enough, in my opinion. We need metrics defined in advance, clear to citizens and political actors, and tied to impact. Otherwise, if the threshold floats, exception become discretion. To this, we should also add a reflection on the courts themselves. Some authors say that constitutional courts are the best place to apply militant democracy measures because they are far from day-to-day political and popular pressures. That's true, but some problems remains. In fact, the court, we have to remember that the court are small, are composed by small group of people unelected, and they are no less fallible than other constitutional actors. The second question, the second aspect that is linked to the case analyzed is the minimum effective remedy. Annulment, suspension of an election, or every kind of decision that are applied on an electoral law should remain ultima ratio. There is a simple question that we have to ask to ourselves. Is there a less intrusive measure that we can restore fair condition in time? If yes, ultima ratio is not justified. Third, the temporality of the exception. Emergency tools tend to become precedent. Precedents tend to become practice. To avoid this, we need sunset clauses and a public ex post review to measure impact, check proportionality, and fix the law if needed. That said, let me move to my conclusion with a basic premise. Today, the threat to the foundation of democracy come not so much or not only from anti-system party, as in the time when Loevestein set out its thesis, but from new and more complex architecture and behaviors, especially digital, such as bot troll network, unlawful micro-targeting, pressure on electoral system. So, bringing militant democracy ideas into the middle of an election is an high-risk constitutional surgery. It could be accepted, but only under strict conditions. The safer path is before and outside the courtroom, as I said, in clear rules defined in advance, rapid and transparent administrative powers, and in public accountability. In this way, courts remain guardians and not become sovereigns. The integrity of the vote is protected without suspending it, and legitimacy continues to come from the vote and to be kept by legality rather than being replaced by a judgment. Thank you.
Indeed, Chiara, militant democracy is one of the most, complex tool and concept in political theory, not only in constitutional theory. The devised by Karl Löwenstein, but over the years evolved. But I think that if we compare to what Karl Löwenstein meant by militant democracy with what Jan van der Meulen, for instance, more recently meant by the same formula, we can see a lot of differences, and that's why I think that this is a very crucial issue. Thanks so much. Okay, so first I'm gonna give the floor to Dora Trombella, who is a PhD candidate in constitutional law at the University of Pisa. She's gonna talk about another very interesting case study. So thanks for bringing Bolivia to the comparative law table. She's gonna present on presidential re-election in Bolivia, what happens after the Tribunal de Constitucionalidad Plurinacional overruling. Happy to discover that. You have 12 minutes. Ready where you are.
Thanks, and thanks a lot to the workshop organizers for this opportunity. Today, I would like to focus on the Bolivian case, specifically regarding the relationship between elections and the Bolivian Constitutional Court. With the democratic transition in Latin America starting in 1980s, many countries adopted the new constitutions and set up presidential forms of government. This choice follows the Ibero-American constitutional tradition, which goes back to the time of Bolivar. Unlike the US model, where the president's power is controlled by a system of checks and balances, Latin American presidentialism tends to concentrate most powers in the hands of the executive. For this reason, it is called hyper-presidentialism. A clear example of this modern hyper-presidentialism is the figure of Evo Morales in Bolivia. Morales won the presidential election in 2005 with an absolute majority of the votes. This result reflected a strong desire for change after the previous governments failed to address the needs of indigenous people and campesinos. Morales' political strength as a leader of the Movimiento al Socialismo, MAS, comes from making the emancipation of indigenous people a central part of Bolivian political life. During his first term, Morales also approved a new constitution designed to reflect the interests of a society that had changed deeply. In 2009, Morales resigned a year early so he could run again the next year and get full approval from the people during the constitutional referendum. Regarding presidential re-election, Article 168 of the Bolivian Constitution sets a 5-year term and allows the president to be re-elected only once consecutively. Reading the provision, it's clear that the limit is not absolute. It only applies to immediate consecutive terms. In other words, there is no strict limit on the number of presidential terms, except that a president cannot serve immediately after 2 consecutive terms. During his second term, Evo Morales continued the policies of his first. Constitutional reforms further make his position stronger, giving him broad legislative powers and reducing the role of parliament. Morales was able to run for a 3rd consecutive term despite the constitutional restriction. On this point, the Tribunal Constitucional Plurinacional ruled in a 2013 judgment offering a broad interpretation of the Constitution. In short, he held that Morales could run freely because he had not completed his first term and had resigned before its natural end. This interpretation was later incorporated into a law, although an infra-constitutional law effectively made a significant change to the Constitution, paving the way for Morales' 3rd term in 2014. After his 3rd term, Morales could not legally run for a 4th term. For this reason, the MAS proposed amending Article 168 of the Constitution to allow unlimited re-election for all institutional offices, including the presidency. The reform was put to a referendum on February 2016, but by a very narrow margin, 51% more or less of the population voted against it, confirming the ban on more than 2 terms. After that, a group of MAS parliamentarians filed a case before the Tribunal Constitucional Plurinacional to highlight an internal constitutional conflict between Article 168 of the Constitution and a fundamental principle, the right to vote and to stand for election, guaranteed by the Constitution as well as by various international human rights conventions. The courts accepted the appeal as an abstract unconstitutionality action and ruled that political rights are part of the so-called block of constitutionality, meaning they must be interpreted in accordance with international treaties and take precedence over certain internal constitutional provisions. In other words, if a domestic law limits political rights recognized at international level, according to the court, it must be disregarded. In this case, the Tribunal Constitucional Plurinacional declared that the restriction on re-election beyond 2 consecutive terms were discriminatory and violated the principle of equality, effectively allowing Morales to run again. Morales' fourth election in 2019 took place in an already fragmented political context, with declining support for the mass and rising tensions. During the vote count, the computer system experienced a halt and later reported manipulated results favoring Morales. The situation sparked widespread protests and civil clashes, forcing Morales to resign and to go into exile. However, the story does not end there. An interesting case about the presidential re-election is the 2021 advisory opinion of the Inter-American Court of Human Rights. In 2019, Colombia asked the Inter-American Court for advice on whether indefinite presidential re-election is allowed under the Inter-American Human Rights system. And in this case, the court concluded that indefinite re-election is not a human right under the Inter-American system. Banning indefinite re-election is compatible with the American Convention. Indefinite presidential re-election goes against the principles of representative democracy. States must set clear limits on the exercise of power that respect necessity and proportionality. However, the court clarified that if there are one or multiple constitutional periods between terms, it cannot be considered indefinite re-election. The court's approach was also followed by the Tribunal Constitucional Plurinacional in a 2023 decision. The decision arose from an amparo appeal filed by a lawyer against the regulation governing the selection of candidates for judicial bodies. In fact, the regulation required that candidates have not expressed political positions in public. The lawyer argued that this requirement violated the right to freedom of expression and citizenship. This restriction was unconstitutional and contrary to international treaties. The Tribunal Constitucional Plurinacional issued a very detailed decision and used the opportunity to discuss presidential re-election, offering its own interpretation of Article 168. Drawing on considerations from the Inter-American Court, according to Article 168, the president can serve a 5-year term and be re-elected only once. The court explains that this is clear from the wording of the article, which states that the president can be re-elected por una sola vez. Therefore, it's not possible to run for a third term, whether consecutively or not consecutively. According to the court, the Constitution allows only one consecutive re-election to ensure the government program can be completed, but it excludes indefinite or alternating re-election to prevent the perpetuation of power and the formation of a hidden dictatorship under the guise of democracy. The decision overrules the 2017 precedent. It goes beyond what the Inter-American Court said. The court only clarified that consecutive re-election for more than 2 terms is not allowed, but if there is a constitutional period between 2 terms, it's not possible to talk about indefinite re-election. And for this reason, someone argued that it is a political decision aimed at allowing Evo Morales to run again. After the 2023 ruling, the Tribunal Constitucional Plurinacional issued an auto constitucional at the end of the 2024. This was a formal decision to clarify and confirm the earlier one. Such rulings interpret the constitutions and make it binding in a specific cases. Here, it clearly stated that no Bolivian politician can serve more than 2 terms, consecutive or not, at any level of the states. At last, on May 2025, Bolivia's Constitutional Court issued a key ruling on presidential re-election. The court said that president and vice president can only serve 2 terms, consecutive or not, and a third term is not allowed under Article 168 of the Constitution. Laws that might have allowed a limited re-election, like parts of the Law 381 of 2013 and the electoral regime law, were partly struck down. In short, the Tribunal Constitucional Plurinacional confirms the principle of term limits, safeguards political pluralism, and makes it clear that no former president can seek re-election after 2 terms. In 2025 election, Evo Morales was barred from running. The Tribunal Constitucional Plurinacional ruled that no one can serve more than 2 presidential terms, and Morales had already served 3. Well, one possible reason of overruling in Bolivia is that judges are politically elected and often align with the government or political interests. In fact, with the new constitution, Bolivia provided for the direct election of natural judges, a measure born from distrust of traditional politics and aimed at improving direct democracy. But, for example, in 2017 elections were heavily controlled by the mass, the elections. In this case, 65% of the votes were null or blank, signaling widespread dissatisfaction. Direct election can maybe increase the court's democratic accountability, but can also politicize the judiciary. Elected judges may be influenced by public opinion or political pressures, which can lead them to change decisions over time, creating fluctuation in legal interpretation. In conclusion, Article 168 of the Constitution is unclear and open to judges' interpretation, although the Tribunal Constitucional Plurinacional is relatively stable at the moment, but I think its close political connections mean that future shift in how the law is interpreted cannot be ruled out. Thank you for your attention.
Thanks indeed, Dora, also for framing this very complex series of decisions in light of a sort of multi-level perspective, bringing the Inter-American Court of Human Rights as well, into this picture. Thanks so much. And now we have Matteo Vecchi, who is PhD candidate in comparative public law at the University of Pisa. Is going to talk about guardians of democracy, constitutional courts as preventative guarantors of electoral integrity in the digital age. Matteo, ready where you are? You have 12 minutes.
Thank you. Thank you, Professor. And before starting, I'd like to thank Professor Sperti for today's opportunity in the context of Circle U, of course, and Dottoressa Rachele Bizzarri for her help in this month prior to this event, as called. And lastly, to all of us colleagues that we are here, and we are very lucky to have a possibility to share a moment of confrontation in University of Pisa in this, I think, tremendous period of time. So it is an honor for me to address the esteemed gathering of on the critical theme of constitutional courts and the electoral integrity process, a topic that reveals some of the most pressing challenges and promising prospects facing contemporary democracies. In these minutes, I will try to explore how constitutional courts act as guardians of democratic process, particularly focusing on their evolving role in safeguarding electoral integrity amid the rapid transformations brought about by the digital age. Democracy at its core is founded upon the competition between political parties and candidates who embody competing visions for society. This competition must unfold on a level playing field underpinned by the rule of law and constitutional principles that guarantee fairness, transparency, thank you, Professor, transparency and equality. Here, constitutional courts have a pivotal space, not merely as referees of election day disputes, but increasingly as proactive guardians of the entire electoral cycle, especially regarding the pre-electoral phase. In recent years, new forms of electoral manipulations have emerged, accompanied by the rise of digital technologies and data-driven strategies. Disinformation campaigns, illicit and opaque campaign financing, and manipulative micro-targeting algorithms threaten to distort the free formation of public opinion and thus undermine the authenticity of popular will. These challenges extend far beyond traditional questions of ballot validity or procedural compliance that we are all aware of and as some kind of direct precedents in history, like the so-called rotten borough in the Victorian age, which were, in short, a form of manipulation for electoral results. These challenges strike at the very heart of democratic legitimacy. As detailed in recent considerations, especially in post-authoritarian and transitional system, constitutional courts frequently hold a mandate that general courts lack: the explicit responsibility and capacity to interpret and uphold constitutional guarantees, including fundamental electoral rights. In many systems adhering to the Kelsenian model, constitutional courts enjoy independence from ordinary judicial hierarchies. They have broader authority in a draw upon not just the letter of statutory law, but also constitutional standards, international legal norms, and even general principle of justice to resolve electoral disputes. Empirical evidence confirms that, as a cluster, constitutional courts are more likely than their ordinary counterparts to embrace such standards, emphasizing the legitimacy and integrity of the process over procedural formalism. In doing so, constitutional courts become horizontal accountability actors of the first order. Their activism in the electoral field promotes a higher standard of democratic quality, bridging purely legal interpretation with the democratic aspiration of constitutional text. This role has proven especially crucial where political transitions are fragile, partisanship is virulent, or statutory law leaves significant gray areas for judicial interpretation. Against this background, the potential role of constitutional courts as proactive and preventive guardians of electoral integrity acquires importance. Firstly, it's important to clarify the current landscape regarding the involvement of constitutional courts in safeguarding electoral processes. In many established democracies, in fact, constitutional courts' engagement is often limited, particularly outside the realm of a referendum's adjudication, which follows distinct legal logic and concerns. Notably, explicit and proactive judicial oversight of electoral legislation and processes by constitutional courts is underdeveloped, especially when it comes to ensuring fairness throughout the entire electoral cycle. I will now focus on 3 examples from constitutional and federal Supreme Courts, examining their approaches to evolving landscape of intervention in electoral processes, identifying at which stages of the electoral cycle this intervention occur. A paradigmatic example occurred in Romania in 2024, where the Constitutional Court preemptively banned the political micro-targeting funded by untraceable sources, as we saw today. The court recognized that financial opacity in political communication severely damages voters' right to obtain accurate and reliable information necessary for genuine electoral choice. This anticipatory ex-ante intervention marks a critical evolution in constitutional adjudication, moving the court's role from reactive referee to preventive guarantor of electoral integrity. Such judicial vigilance is neither uniform nor automatic. It depends heavily on the institutional design of courts, the political culture within which they operate, and the doctrines they develop concerning democratic principles. Another case can be brought up from the Swiss model of direct democracy, where continuous citizen engagement in political decision-making coexists with a multi-party representative system. Switzerland's frequent referendum and initiatives ensures that the political parties must remain connected to public sentiment beyond electoral cycle, fostering a political culture of transparency, responsiveness, and direct accountability. The so famous 2016 Swiss referendum for more marriage and family, no two disadvantages for married couples, which called for the complete elimination of any tax disadvantages for married couples, showed how disinformation campaigns were proven to have compromised the free consent of the electorate. For the first time in history, the Swiss Federal Supreme Court's decision to repeal the referendum underlined the principle that electoral integrity demands not only procedural correctness, but also an authentic, informed consent obtained by manipulation. Materially false information from government authorities mislead voters during the campaign, the result being that the court annulled the referendum outcome to preserve democratic legitimacy and genuine consent of the governed. By comparison, and possibly by contrast, the Italian constitutional framework maintains a strong parliamentary sovereignty and limited pre-electoral judicial review significantly. In Italy, the constitutional framework has traditionally impeded the effective judicial oversight of election laws before elections, reflecting a cautious respect for parliamentary sovereignty and the political nature of electoral regulation. Nevertheless, recent jurisprudence has begun to recognize the special constitutional character of electoral legislation as fundamental for democracy itself, justifying a more proactive judicial posture aimed at preventing democratic erosion before it manifests in distorted electoral outcomes. Despite these differences, these three cases converge towards a shared objective. Reinforcing electoral integrity through judicial mechanisms requires anticipatory standards on political financing and communication, interinstitutional collaboration protocols between courts and electoral bodies, and judicial procedures adapted to the temporal demands of electoral cycles. Comparative analysis reveals also several key features that characterize the most robust systems of electoral judicial protection. First, the establishment of anticipatory standards on matters such as political financing and campaign communication is essential. This provides a clear legal framework within which courts can assess compliance and intervene when necessary. Second, collaborative protocols between constitutional courts and independent administrative bodies foster effective and timely monitoring of electoral process, combining judicial authority with technical expertise. Third, expedited judicial mechanisms tailored to the pre-election timetable ensure that intervention occurs early enough to prevent harm rather than to merely correct it ex post. Underlying this evolving constitutional doctrine on electoral integrity is a theoretical reconsideration of democratic participation itself. The digital revolution has revised the long-standing debates about the nature of political parties, mediation, and direct citizen involvement. It has also introduced the novel challenges, the fragmentation and the polarization of public discourse within online platforms, the risk of filter bubbles and echo chambers, and the increasing opacity of information flows shaped by powerful private actors on and off social media. A recent example has been brought to light in Italy by secret services reporting about unusual financial activities involving the Russian embassy in Italy. Specifically, in 2022 and 2017 elections, the Italian Financial Intelligence Unit detected cash operations amounting to several hundreds of thousands of euros. Withdrawals in cash exceeded the 400,000 euros, including large sums delivered in 100 euro banknotes. In this context, we need to take into consideration that the digital age offers both opportunities and challenges for democracies. As technology continues to evolve at an unprecedented pace, it is crucial for the governments and citizens alike to remain vigilant in monitoring the impact of digital technologies on democracy and to take measures to mitigate any negative effects that arise. In particular, the integrity of the judicial freedom of the press and the protection of free speech face unprecedented challenges in the digital realm and in the present time, I would add. Judicial independence, which I did not examine in this dissertation but is on the level field of the discourse, may as well be undermined by the pressure of public opinion amplified through online platforms. Sorry. Constitutional courts, stand at the crossroads in democratic governance. Their traditional role as referees of election fairness is being expanded and transformed in response to unprecedented electoral threats posed by digitalization and political innovation. To fulfill their crucial mandate, courts must adopt a preventive judicial approach that embraces anticipatory standards, cooperative institutional frameworks, and the capacity for swift intervention. At the time, this judicial vigilance must be complementary by a broader commitment into democratic renewal, one that integrates rules emerged from lessons of historical party politics, the possibilities of direct citizen involvement, and the sober management of technological challenge. In conclusion, constitutional courts must not be merely reactive agents in constitutional crisis, as I said before, but proactive architects of resilient electoral systems. By safeguarding transparency, fairness, and the authentic formation of voter preferences, they shape democratic prospects, not just for today, but for the evolving challenges of tomorrow's political landscape. It is incumbent upon all us, scholars, jurists, and policymakers to support and innovate this vital constitutional function and bodies as we navigate the complex interplay between democratic ideals, emergency, and realities. Thank you for attention.
Thanks, Matteo, for stressing the importance of how can I call it, holistic approach, which tries to situate, courts in light of a broader institutional context, as you said, the main courts also need institutional cooperation with other actors. So I really enjoyed your presentation. Thanks so much. So I think I don't know if I'm supposed to say something to guide or to open the discussion. We have 19 minutes. So I'm going to say something, trying to find the fil conducteur, the connecting the very different actually presentations, and then if there will be time, perhaps you will be asked to give your 2 cents to what I'm going to say. Well, I think that these presentations are very different. They brought different case studies, but they have, I would say, 1 to 5 points, I would say, in common. So at least, I mean, they touch upon, and I will say, 5 main points. The main first point is has to do with the comparative and conceptual framing. We have not only seen different national models that have been analyzed looking at different rules, standards, looking at how different courts apply them, but we have also probably witnessed the existence of different notions and concept of electoral integrity. And that's our, say, very important premise, which in a way explains why in this contest, contest matters, indeed. I think it's a crucial element. So the point is, being comparative lawyers, the point is actually trying to verify whether these different conceptions of electoral integrity have been, in a way, I mean, converging under the pressure of EU law and under the pressure of under the international standards, or if they are diverging. Also take into account this new wave of sovereign strength, which of course is an element to be taken into account. A second element that has to do with this the comparative and conceptual framing is the type of judicial review, let's say, performed by courts, sometimes the constitutional court in this context. To what extent is judicial review of election a distinct function when compared to ordinary judicial review or administrative oversight? And does the comparative evidence suggest a trend towards empowering constitutional courts in this field or not? I think that more in general, and this has been mentioned by many presenters, it is evident that sometimes we ask too much of the courts. Understanding, or conceptualizing them as if they were isolated actors. Actually, they don't work in a vacuum, and that's why it's very important to stress, as we did when commenting on the Swiss case, how the other institutional players, I mean, react to decisions like this. I think that strong courts definitely need robust political institutions. Otherwise, they can remedy some issue that we can have in the short period, but in the long run, as Andrew Arato pointed out, they risk being captured by the political power. I think this is, and that's why I said with scholars, I mean, sometimes ask too much of the courts, that I mean, forgetting that that they operate in they don't work in an empty space. Sometimes we blame them for being too shy. Sometimes we actually accuse courts of being too proactive. But very frequently we don't take into account, I mean, the other relevant players. The second element that has been recalled by the different presentation is the relationship between courts and digital disinformation / misinformation. I do believe we had a very nice discussion this morning. I do believe that the crisis of liberal democracy as we know it is not only rooted in a problem of disinformation, but disinformation and disinformation certainly manner. I think that's they are the in a way, I mean, manifestation, the intimation of a broader crisis, but they are really important. So what the role of courts when dealing with digital disinformation? The problem is that we have, with some exceptions, the Inter-American courts, the Venice Commission, the Court of Justice, but we are mainly focused on national courts. And the problem is that digital disinformation is notoriously fast moving, that you mentioned that, Matteo, but also transnational in nature. No, I mean, it is actually part of a sort of hybrid strategy frequently conducted by foreign actors. No, I mean, so what tools, if any, can constitutional courts, national constitutional courts, realistically deploy to address harms that may occur within hours or days before litigation can even begin? That's another issue. Do courts risk overstepping the democratic boundaries when acting proactively or ex officio against disinformation? How can they balance urgency with the procedural fairness? I think that Theodore mentioned the importance of procedural details, and with the procedural fairness and robust evidentiary standards. That's another issue. The third element is the importance of case studies. In particular, the Romanian case has been presented as a stress test, but I have some questions in this respect. Does this case indicate a structural weakness in terms of lack of procedural safeguards or evidentiary thresholds, or is it a necessary assertion of constitutional guardianship? What lessons should other jurisdictions draw or avoid from these precedents? How should comparative scholars distinguish between a court's legitimate protection of democracy and potential judicial overreach or politicization? We mentioned this risk, when dealing with the case of Moldova, if I'm not wrong. The fourth element has to do with the institutional ecosystem, I would say, beyond courts. And Dachele stressed the importance of what she called knowledge institutions. I mean, actually other papers as well mention the importance of knowledge institutions, fact checkers, but also academia, universities, think tanks, and international bodies like the Venice Commission. How do these actors complement or constrain, why not, or constrain constitutional courts? Are there good models of multi-level coordination that others should emulate? And also the Inter-American court, the Inter-American case is very interesting. Could international standards or soft law instruments, and this brings me back to the first presentation given by Julia. Is soft law really soft? In this context, especially when it is used and deployed by national constitutional actors, so that in a way contributed perhaps to making soft law hard in a way. And this leads us back to the never-ending debate about the very nature of soft law. I mean, the article by Francis Knight, which she wanted to pointed out that also soft law actually can be in a way legally relevant, and sometimes it can be codified, I mean, in hard law measures. So there is no, I would say, real and hard line between soft law and hard law sometimes. So can soft law instruments meaningfully, contribute to harmonize responses to electoral disinformation without undermining national constitutional identities, which is also a relevant factor when dealing with the European Union legal context. As we know, Article 4.2 of the Treaty of the European Union recalls the duty to protect national identities. The final point has to do with, I would say, broader democratic theory questions. So, and this leads me back to the presentation given by Temanol on Brazil. No, is there a risk that framing disinformation primarily as a legal problem may obscure the underlying political, social, and media dynamics? That's another big question. Should the constitutional design evolve to include explicit provisions on digital integrity of elections, or can existing constitutional principles, those principles also evoked, you mentioned mangled, no? These unwritten principles, or can these unwritten principles adequately, in a way, address new technological challenges? So, these are questions that I would like to, in a way, trigger. Now we have 9 minutes. I don't know if we have time, to have a round of quick answers, but I wanted to say something, to really galvanize the incredible richness, in terms of scholarship that we enjoyed this afternoon. I took a lot of notes that I really encourage you all, to come up with an article, a paper, something, because I think that you have the enthusiasm and the international debates. And so I want to close my intervention by thanking once again the Professor Angioetta Sperti and Dr. Rachele Bizzarri for giving me the possibility of learning so much, and also for giving me the possibility of meeting for the first time in person Dragos Kalin, because we had some webinars during in pandemic times. This is the first time I met him in person, and I learned a great deal, of course, from his presentation. So thanks so much. I give now the floor perhaps to Professor Sperti. Thank you.
Just a few words to thank Professor Martinico, who coordinated this roundtable. Unfortunately, we have a very tight schedule, and he has to take a train, so we have to close on time. But I'm sure that there will be the opportunity to answer his questions, his remarks in the following publication that we have planned. So we have already an agreement with the University of Pisa publisher, the University of Pisa Press, for an open access volume, which will be published also on the website of the Jean Monnet module. So we will be in touch with the deadlines and all the instructions for for the publication, which we hope could be released in the beginning of 2026. So thank you very much again. It was, I think, it's today's lectures and roundtable raised many different issues, but also many different questions. Addressed the topic from different perspectives, but also raised, as Professor Martinico said, many questions which still remain open. So I'm confident that the publication will also offer us the opportunity to focus on the most problematic issues which are still open. So thank you very much.